Beg leave to withdraw the amendment.
Yeah.
Is it your Lordship's pleasure that the amendment be withdrawn? Amendment by leave withdrawn. Amendment 438 EC not moved. We come now to Amendment 438 ED. Baroness Kidron.
My Lords, I rise to move the amendments in this group, and I thank the noble Lady Barran, Lady Morgan and the noble Lord Clement-Jones for their support. My Lords, it is heartbreaking to be here again. I first raised this issue over 4 years ago after witnessing Senior Coroner Walker's difficulties in obtaining data from US tech firms during his investigation into the death of Molly Russell. Coroner Walker, Ian Russell, Molly's father, and the family's lawyers fought for years to secure data that revealed the role that played by Pinterest and Meta, and this evidence was central to the coroner's finding that both services, I quote, contributed to her death in more than a minimal way. My Lords, data is crucial. The original amendments were also recommended in the pre-legislative Joint Committee report on the draft of the Online Safety Bill. We debated them at length during the Online Safety Bill. We got agreement to put them into the Data Protection and Digital Information Bill that fell when the election was called. We tried to push them through in wash-up. And finally, after years of campaigning by bereaved families, they were included in the Data Uses and Access Bill last year. My Lords, I say all this because when the noble lady, I think, the minister, replies, I want her to carefully weigh up her words, knowing that the bereaved families who have worked so hard to pass these provisions for so many years, some of whom are in the gallery today, are still waiting. Yesterday, I met several bereaved parents. Bereaved families, including Mia Janin's father, Mariano, who held a photograph of his daughter as he described a recent meeting with the Secretary of State, Liz Kendall. He said, I thought it was a good meeting until I realised it was the same meeting that we'd had with Peter Kyle a year ago, except this year we needed a bigger room because there are more bereaved parents and more dead children. I also heard yesterday of a newly bereaved parent who tried to get the police to access her daughter's data only to be told by Gloucestershire Police Occupational Health Department to talk to Ellen Roome. She knows more about how the law than the entire police force. And I spoke to Ellen, who is with us in the gallery, and she told me that the police downloaded her son Jools' data in 2022 but are only now beginning to examine it. My Lords, we have a law, but it's not working, and I want to set out 3 reasons why. First, while coroners can ask Ofcom to issue a data preservation notice that require online services to retain data in advance of issuing a Schedule 5 notice, they are not routinely doing so. And while Section 101 enables Ofcom to use its information gathering powers when it receives a Schedule 5 notice from a coroner, they are not routinely doing that either. My Lords, I have 8 separate letters from the government saying who has been written to and outlining what guidance has been sent to whom, but still bereaved parents are coming to my door. For some, the loss of their child is still raw, and they're blindly trying to work out the system. Others are heartbroken that the opportunity to preserve data is long gone because they found out about the law too late. Sometimes the coroner does not know the measure exists or does not understand that data disappears and wants to wait for the police investigation before even considering such a request. All of these different reasons undermine the fundamental purpose of the law. And I want to be absolutely clear. I have no criticism of the coroners themselves. They are not experts in digital systems. They cannot reasonably be expected to know that even a brief engagement, such as hovering over a link or pausing on a piece of content, can influence how an algorithm responds. Nor are they expected to know that platforms routinely infer and group children into behavioral cohorts, for example, relating to low mood, late night use, social isolation, or identity exploration, or are they supposed to know that seemingly fleetingly online interactions can actually leave persistent data traces? My lords, the measure was specifically designed for Ofcom to take that burden from the coroners, but that has not happened. Amendment 474 makes the issuing of a data preservation notice automatic, issued to relevant services within 5 working days of becoming aware of a child's death. It requires Ofcom to provide a template that ensures a consistent baseline of data is obtained, and it also allows the coroner to add any information they additionally wish to request. It does not undermine the coronial system, it makes it sure-footed. Amendment 475 is consequential in that it requires the Secretary of State to write to relevant stakeholders to raise awareness. My lords, the Chief Coroner issued guidance at the end of September when these powers came into force, but it's clear from the testimony of bereaved parents it has not been fully absorbed. My lords, the only argument I have heard from government against this approach is the administrative burden should it apply to children who die as babies or of childhood illness. But an exemption could surely be made. Meanwhile, making the preservation automatic, offering a template of what information should be preserved, and publicising the fact is the minimum we can do for parents whose children have been murdered, manipulated into extreme challenges, or who commit suicide as a result of online anxiety. My second issue is that during the passage of the Online Safety Bill, we were promised that the then government would make arrangements to ensure that the tech companies, largely based in the US, would comply with requests from Ofcom in the UK to supply data, knowing that there were conflicting legal requirements. The Noble Lord Parkinson, who is in his place, and I hope he will confirm his own words, from June 22nd, 2023, said then, we will engage our American counterparts to understand any potential and unintended barriers created by the US Stored Communications Act. I can reassure the Noble Lords that these matters are in our mind. On that basis, and on the basis of detailed private conversations with government and officials, we understood the government was making an arrangement with the US government about any conflicts of our respective data law. But, my lords, I had a recent meeting with Minister Mariano, and in the meeting, he did admit that no such arrangement has been made with the US. Since then, I called former Secretary of State Michelle Donnellan, who confirmed that she had reached out to her counterparts, Secretary of Commerce Gina Raimondo, in the previous US administration, but that conversation was not completed before the general election. So, my lords, it seems that the intention to secure the legal basis upon which both the data preservation notice and the coroner information notice could be served has been forgotten. In October last year, in his Prevention of Future Deaths report on Leo Barber's inquest, Coroner Edmund Gritt wrote, I issued a Schedule 5 notice to Ofcom to exercise its power under Section 101 Online Safety Act 2023 to obtain evidence from Google relating to Leo's online activity before his death. No material was provided by Google under this procedure. I understand that Google's position is that the service provider holding such data, Google LLC, is not within the jurisdiction of England and Wales, but is within the US jurisdiction and subject to the laws of the USA, which prohibit compliance with my Schedule 5 notice under the Section 101 process. He goes on to say that if this continues, it will risk all future investigations. Meanwhile, in a particularly confusing episode, 2 months later, in December, in response to a Freedom of Information request, Ofcom said, "To date, there have been no Section 101 coroner information notices or data preservation notices which a service has failed to respond, nor to which a service has failed to provide relevant information requested." My lords, both cannot be true. This is a pattern of failure to properly implement the Online Safety Act as a whole. And in spite of several attempts to meet with ministers, after speaking to both Ofcom and the former Secretary of State, I rang 2 of the relevant companies in the US, and both suggested a practical path forward that would allow our law to be fully enacted. So I really hope, when responding, the minister will fully update the House if a deal has not been done, and agree to meeting with all relevant ministers as a matter of urgency to discuss the proposals I received, which I have tried to tell the minister and not been granted a meeting. Finally, my lords, the amendments 483ED and 483EE, which are new because there is a gap. Amendment 483ED requires the Secretary of State to amend the Criminal Procedure and Investigations Act 1996, so the Code of Practice governing police investigations is updated to make online harm a primary line of inquiry. It would require the early seizure and examination of relevant digital devices, the prompt capture of digital and account data, and the proper documentation of a child's activity on known online services. It would also require police to report any evidence of breaches to the Online Safety Act to Ofcom. Amendment 483EE is consequential. It requires Secretary of State to raise awareness of these powers and of good practice in digital investigation by writing to relevant stakeholders. My lords, digital and online activity is often essential to understanding how and why a child has died. There is no statutory guidance on how police should investigate, and what guidance there is, no presumption that a phone should be checked. Many forces lack the expertise to know what data to collect, what devices to examine, or that data available immediately may rapidly degrade or disappear. As a result, grieving parents are left to fend for themselves at the worst moment of their lives. And if they miss that moment because they do not know, the police do not know, the pain is compounded in the most cruel manner. Just this morning, I received a letter from the Minister explaining he's written to colleagues and to the Chair of the National Police Chiefs Council, who is working now on guidance on the collection of digital forensic data. But, my lords, I also have a letter in my possession from the previous minister to Ellen Roome, who last June said exactly the same thing. We do not yet have guidance, only the promise of it, and I am now as concerned about its content and our opportunity to contribute to it as I am about its timing. Ahead of this debate, I heard from Stuart Stevens, whose son Ollie was murdered in 2012. In the immediate aftermath of Ollie's death, the police told the family to go home and screenshot as much of his phone as they could. For the first 3 hours after his death, in shock and grief, they did exactly that. My lords, it is not right. Stuart recently told me that he was mortified. He said, "In our case, the lack of data meant the difference between murder and manslaughter, and the female that instigated my son's murder is out and off license, free to pick up her life where she left off, leaving us with a life sentence." My lords, the amendments in this group have his support, the support of many current and former police investigators, of Ellen Roome, of the wider community of bereaved families, and I pay tribute to that community that does so much vital work, but no one wants to be a member of. My Lords, if the Minister has technical concerns about these amendments as drafted, I will work with them to improve them. But I have been here 4 times now, and I no longer accept no for an answer. So if rejected, they will be back at report. And let me say finally, the government awarded Ellen Roome an MBE recently. And I believe, and I haven't asked her, but I believe a more fitting recognition would be to give her what she has long fought for, Jools Law, by accepting these amendments so that data collection is automatic. They are practical, they are necessary, they are long overdue. I beg to move.
Yeah.
Amendment proposed after clause 166, insert the new clause as printed on the marshalled list.
My Lords, it is with a mixture of sadness and pleasure that I rise to follow the noble Baroness Lady Kidron and have added my name to the amendments in this group. Much of this bill impacts in small ways the lives of many citizens in this country. But these amendments, which I hope very much the government will accept, would have a huge impact on the lives of a small group of families whose children have died and who are seeking to understand what led to their death. And as the noble Baroness Lady Kidron said, it's a club which none of those members wish to be part of. In particular, like Baroness Kidron, I'd like to pay tribute to Ellen Roome, mother of Jools, who died inexplicably aged 14, and who has found herself at the front of a national call for change in relation to children's access to social media in general and to these specific issues which have impacted her family and other families so cruelly. My noble friend Baroness Morgan of Coates, who cannot be with us today, told me how moved she was in particular when we met with Ellen recently, and I can only agree. As the noble Baroness Lady Kidron set out, these amendments would achieve 3 things. Firstly, they would explicitly bring the attention of the investigating officer to the digital and online aspects of a child's life. The code of practice for officers feels like it was written in another age. Maybe 2020, which I think is the latest version, was another age. And again, we've heard that we owe thanks to Stuart and Amanda Stevens, who have highlighted this gap following the murder of their son, Ollie. There's not a single reference to digital evidence in the code, just one reference to the fact that physical evidence can be captured digitally. But given how much of a child's life is now lived online, it's vital that it's investigated properly and at the earliest opportunity. And our amendment 438 ED would bring this early investigative focus and would give the police the opportunity to alert Ofcom if they believe that a platform is not complying with the Online Safety Act. The second thing that these amendments would achieve is that vital digital evidence would be systematically requested by coroners in the case of the death of a child aged between 5 and 17. And the draft template would ensure that all relevant information is provided in a completely consistent manner, as well as giving the option to include any other relevant information for a particular case. And currently, as the noble Baroness Lady Kidron said, despite recent improvements in legislation, there is too much left to the discretion of coroners, many of whom may be unaware of their new powers that they hold both in relation to coroner information notices and data preservation notices. And without this, recently bereaved families are expected to request information themselves from a platform through the horribly titled deceased user duties. So I looked at the help section of the Facebook website, which says, and I quote, Now imagine, my lords, that you're a recently bereaved family. You've just logged in. This is what you hear. In rare cases, we consider requests for additional account information or content. You will be required to provide proof that you're an authorised representative, e.g. family member, and a court order. Please bear in mind that sending a request or filing the required documentation doesn't guarantee that we'll be able to provide you with the content of the deceased person's account. In addition, we'll memorialise the deceased person's account once we receive your request. If you'd like to send us a request, please contact us. Well, I will leave your lordships to judge the tone of that. Ofcom has a live consultation on their draft guidance. In this, they recommend the following: that platforms should be clear that they will acknowledge a request, who will communicate with parents, what the next steps are if the information provided by parents is incomplete or unclear, what internal steps they will take, what the timeline will be for providing a response, what other evidence might be acceptable if the parent doesn't have an official ID document, and detail on what information they will never disclose, explain whether special software will be needed to access any disclosed information, and whether they provide that software, and how any information would be delivered. It won't surprise your lordships that not a single one of these things was clear on the Facebook site when I went to look. I didn't have time to check any others. So to be clear, these amendments would achieve a third very important thing. They would give clarity and confidence to parents that they will get answers to their questions about the death of their child that relate to their social media usage. It's a disgrace that we still have a gap in legislation that potentially puts parents through more pain as they open a page where the first line says, "in rare cases." The government can simplify this system immediately by accepting these amendments. I hope the Noble Baroness, the Minister, will say yes when she comes to respond.
My Lords, I rise to speak and express the support of these benches to amendments 474, 475, 438ED and 438EE, which all stand in the name of the Noble Baroness Lady Kidron, and to which I am pleased and privileged to have added my name alongside the Noble Baroness Lady Morgan of Coates and the Noble Baroness Lady Barran. And, my Lords, I pay tribute to the relentless campaigning on behalf of bereaved families by the Noble Baroness Kidron, and to her utterly moving and convincing introduction today. And I also pay tribute to all those bereaved families who have fought for these provisions, my Lords. And I associate myself with everything that she said about the implementation and the intent behind the Online Safety Act, my Lords, which has not achieved what we all set out for it to do. Together, these amendments address a singular tragic failure in our current justice system, the loss of vital digital evidence following the death of a child. There's been powerful testimony regarding what's called the suspension gap, and this occurs when a coroner investigating the death of a child feels unable to issue a data preservation notice because a police investigation is technically active, yet the police may not have prioritised the securing of digital evidence. During this period of hesitation, data held by social media companies is deleted and the opportunity to understand the child's final interactions is lost forever. Currently, many coroners remain unaware that they can request data preservation notices in the early stages of an investigation, and we've heard heartbreaking reports from bereaved parents that coroners feel unable to act while police investigations are active. Because inquests are routinely suspended during these investigations, The data is often deleted due to account inactivity or routine system operations before the coroner can issue an information notice. The Molly Rose Foundation and the Five Rights Foundation have been clear automatic preservation is essential because data is the key to joining the dots in these tragic cases, and we cannot allow another child's digital history and the truth about their death to vanish because of bureaucratic delay. As Ofcom has recently clarified, service providers are not required to retain the data they do not already hold. They simply need to notify the regulator if information is missing. During recent consultations, major providers like Meta and Microsoft did not object to preserving data from further back, provided it was still within their systems. My Lords, too often police seize a physical device but fail to notify Ofcom of potential breaches of the Online Safety Act. These amendments work in tandem. Amendments 474 and 475 freeze the evidence automatically and provide the legal mechanism to preserve data. Amendments 438ED and 438EE ensure that the police and coroners are fully aware of their responsibilities and protocols to collect that evidence. Together, they ensure that potential online harm is treated with the same priority as a physical weapon in every investigation into a child's death. My Lords, these amendments are about ensuring that our coroner's system is fit for a digital age. They provide the speed and technical certainty required to support bereaved families in their pursuit of justice. We cannot continue to allow a lack of process to obscure the truth of why a child has died, and we cannot allow the deletion of evidence to become the enemy of justice. So I do urge the Minister, as have the noble baronesses, to accept these amendments as a necessary modernisation of our investigatory framework.
My Lords, if I needed persuading, and I'm not sure I did, the noble lady Baroness Kidron and her supporters have certainly persuaded me that there is a very serious problem here. And we all know, as legislators who spend hours in this chamber, that law without enforcement is a dead letter in a sealed book and not what anyone wants to be spending their lives on. So if, as it seems, there are gaps of responsibility and agency between coroners, the police, Ofcom, and dare I say it, the great big untouchable tech imperium that monetises our data and effectively monetises our lives, those gaps need to be dealt with. Now, just as I pay tribute to the noble lady Baroness Kidron, not just for her commitment but for her expertise in online harms, I will say that my noble friend, the Minister, is probably one of the most expert and experienced criminal lawyers in your Lordship's House. And so if these precise amendments are too broad and too onerous for catching children who were too young, for example, to have a device, I am sure that my noble friend, the Minister, will be able to address that. And between these noble ladies and other people, other noble lords of good faith, something can be done.
Yeah. I support all the amendments in this group, and I'm glad that my noble friends Lady Barran and Lady Morgan of Coates have signed them on behalf of these benches. I pay tribute to the noble Baroness Lady Kidron and, of course, to all of the bereaved parents and family members who are campaigning still to tighten the law and enforce the law in this important area based on their terrible experiences. We know there are some gaps in the law, and the noble ladies amendment addresses, firstly, the easier one, which is it is one of implementation, making sure that coroners are aware of the powers that the Online Safety Act has given them, and very sensibly her amendments are about spreading knowledge and awareness so that coroners are able, on behalf of the families of young people who've lost their lives in these terrible ways, to find out the truth and hold that to account. And I think that is the easier problem to solve in some ways. And there is, of course, going to be both, as the noble Baroness Lady Kidron said, the coroners are not technical experts. There's always a generational gap. The apps, the social media that are second nature to the young people that are using them can be mystifying to the parents, the coroners, the police that have to look into them in the most terrible circumstances. And we need to make sure that everybody is aware of how the apps work and how the Online Safety Act works too. The noble Baroness in her remarks pointed out a trickier problem, which is the extraterritorial effect, particularly with relation to the law in the United States of America. And she's right that the previous government spoke to the previous US administration to talk about things like the Stored Communications Act, which the noble Lord Allen of Hallam raised during our debates in the then bill, and it was a problem that we were aware of. As she has noted, there's been a change of government on both sides of the Atlantic, and I don't know if the noble Baroness, the Minister, now when she comes to respond, or perhaps later in writing, can say a bit more about the changing dynamics and the discussions that are being had with the present US administration, which clearly is having an effect in the cases, and as we heard from the noble Baroness Lady Kidron, sadly mentioning the inquest into the death of Leo Barber, where the Schedule 5 notice was unable to be brought into effect. So I'd be keen to hear from the noble Baroness, the Minister, either today or later, about the more recent discussions that His Majesty's government is having with the US administration on this important aspect.
My Lords, I fully support these amendments and congratulate Baroness Kidron on her fight to highlight these issues over many, many years, and on her opening remarks. I also pay respect to the bereaved parents who have been campaigning tirelessly and look to us to achieve change. My Lords, it is common sense for coroners and law enforcement agencies to have access to social media accounts of deceased children who are believed to have died as a result of social media activity. My Lords, if it was your child or your grandchild, wouldn't you want that to happen? This action needs to take place automatically before accounts are deleted. Accounts should be preserved, and it should be a criminal offence to delete or edit them before they are viewed by investigators. My Lords, I strongly believe, like so many grieving parents across the country, that social media companies should not be allowed to withhold or destroy often crucial evidence which could be vital to investigations and lead to criminal convictions. My Lords, after hearing on BBC Breakfast News this morning some of the heartbreaking stories from the bereaved parents who are campaigning on this issue and urging government to take more robust action, I was convinced that tragic cases like these clearly highlight the need for social media companies to be compelled to protect our children and safeguard them from harm. This is yet another plea before more harm is done. Because, my Lords, right at this very moment, there is a child viewing harmful content that could lead to tragedy. So I hope the government and Ofcom, are you listening, Ofcom? I want you to listen to these bereaved parents and take further action. And I urge the government to accept these much-needed amendments and act now.
My Lords, I can't match the eloquence of some of the previous speakers, but I just want to quickly add my support for this group of amendments. We've heard the policy arguments for these proposals, and as a policymaker, I think they're overwhelming. I just also wanted to add my support as a parent as well as a legislator. Those of us with children and teenagers know full well how much of a child's life is nowadays conducted on a screen behind a password. Friendships, pressures, influences are impossible to get at without access to that digital record. I want to pay tribute to the bereaved parents who have campaigned with such courage and dignity. They've turned unimaginable grief into a determination to protect others, and I think the whole House will honour what they're doing today. I will very much hope that the government can accept these amendments, and if not, I hope that Baroness Kidron, I know she will be true to her word and continue to bring these back at report.
My Lords, I'm very grateful to the Noble Baroness, Lady Kidron, for moving these amendments, and thank her and many others of your Lordship's House who have given cogent and compelling argument for their inclusion in the bill. It does indeed feel like the dial is starting to shift with regard to the protection of our children from online harms. I'm very pleased, for instance, that your Lordship's House supported Lord Nash's amendment, my noble friend Lord Nash's amendment last week, in voting to ban under-16s from social media. The amendments before us today are in many ways an extension of the argument made last week, namely that social media is not appropriate for children, it is causing irreparable harm, and in the most severe cases, as we've heard today, it is leading to death. As the father of teenage children who, like so many other children, face a world of online temptation, of pressure and influence, these issues are very personal. And there is a lot to be said for creating further duties when there is the death of a child. The issue was of live consideration, I think has been said, in the previous government's legislation, which included a clause that created a data preservation process, and I'm aware that Amendment 474 is different in its text, but the fundamental issue is the same. At its heart, these amendments, or at their heart, these amendments contain a simple objective, and that is to ensure that coroners can access the social media data of a deceased child or their wider online activity where the death is suspected to be linked to that activity. And it is plainly sensible to ensure in that scenario that data is not destroyed so that the coroners can access it for the purposes of investigations. I have nothing further to add given what has already been said, and I look forward to hearing the Noble Baroness, the Minister's reply.
My Lords, I'm sure that your Lordships will all agree with me that we have a great deal for which to be grateful to Baroness Kidron for her work in relation to the online space and its regulation when it comes to our most vulnerable citizens. My Lords, it is so obvious that all child deaths are harrowing and deeply distressing for bereaved families that to say so seems almost trite. But however that may be, I want to start my remarks by acknowledging this in order to make the point that the government has this both front and centre, and anything I say this afternoon should be seen in that context. I want to pay tribute to all the brave families who fought to understand the circumstances that led to the death of their own child. I'm grateful to the Noble Lady Baroness Kidron for telling me that some of the families are in the gallery. I've not had an opportunity to meet them yet, but I extend the invitation to do so now. I also understand that for most, if not all of them, this is not just about the circumstances of their own child's death, but about trying to ensure that this does not happen to other families. We know that the data preservation provisions in Section 101 continue to be a focus both for bereaved families and for parliamentarians who do not think the process is quick enough to stop services deleting relevant data as part of their normal business practices. And we agree that it is a proper and urgent objective to make sure that Ofcom has the powers to require, retain and provide information. Section 101 of the Online Safety Act was, of course, a provision originally introduced following the Noble Lady Baroness Kidron's campaign and amendment during the bill's passage through Parliament. And in order to support both coroners and services, in September, both the Chief Coroner and Ofcom published guidance on this new provision. Ofcom consulted on the draft guidance in parallel and published its finalised guidance in December of 2025. The Chief Coroner's guidance encourages coroners to consider requesting a data preservation notice early in the investigation if the relevance of social media or another in-scope service cannot be ruled out. So this should safeguard against automatic deletion of the data by service providers due to routine processes. The government brought forward the commencement of data preservation notices, which came into force on the 30th of September 2025, and since then, Ofcom has issued at least 12 data preservation notices. And on the 15th of December 2025, the guidance for Ofcom was updated in relation to information gathering powers, including new guidance on data preservation notices themselves. So the government is working closely with Ofcom and the Chief Coroner's Office to understand how effectively these are working in practice. But we have heard concerns about the speed and efficiency of the process. So against this background, I begin with amendments 438ED and 438EE. My Lords, the police themselves accept that there should be better guidance for the application of powers to preserve and access digital evidence in investigations of child deaths in order to ensure consistency across forces. The Home Office and the Department for Science, Innovation and Technology, forgive me, are already work. Can you read this for me for a moment? Sure. Now take over.
My Lords, the Home Office and Department for Science and Innovation and Technology are already working with the police and the National Police Chiefs Council in creating guidance to raise awareness of and promote the consistent use of powers available to the police to preserve and access data following the suspicious death of a child. Officials in the Home Office have been supporting this work where it's been appropriate. That said, we can see why the Noble Lady's idea of updating statutory guidance is attractive.
I'm going to try and take over.
Okay, good.
I'm very grateful to my noble friend for taking over. We can see why the Noble Lady's idea of updating statutory guidance is attractive. And I say now that I would welcome a conversation with her, as she and I have discussed when we met briefly the other day. The government does have concerns that being too prescriptive in legislation may create more problems than it solves, because the legislation would need to be amended every time there were changes in technology or in operational practices. Your Lordships will be well aware, given our many late nights spent scrutinising primary legislation at the moment, of which tonight may be another, how clunky, cumbersome and time-consuming it can be to keep amending primary legislation. So for this reason, it's the government's view that that our shared objective can be achieved using non-statutory guidance. Police forces are well used to applying and following guidance in a range of areas, from missing people to information sharing. But having said that, I do make the point that I would welcome a conversation with the Noble Lady Baroness to see if we can find a way through this by working together in order to do so. Turning now to amendments 474 and 475. Again, this is an issue that the government takes very seriously, and I want to reassure your Lordships that we are carefully considering the issues that these amendments raise and are grateful for the continued engagement of the Noble Lady Baroness Kidron and the bereaved families. Taken together, these amendments would require coroners to notify Ofcom within 5 days of a child's death, triggering a standard form to request data preservation. And once again, we can see the appeal of such a requirement. The problem is that it would apply to all cases of deaths in the over fives, regardless of whether social media may be relevant to their death. So, for example, where a child died as a result of a road traffic collision or of cancer, it's unlikely in most cases that social media retention would be of use to the police or coroner. So whilst the government is sympathetic to the aims of these amendments, it's our view that we need carefully to consider any possible unintended consequences. Before
noble lady sits down, just on that point, does she have a number of children over 5 who die in other ways, just so that the House can understand how much of a burden that might be?
I can't give the noble lady the answer now, but I can write to her with that data. So our view that we need carefully to consider any possible unintended consequences, the need not to place a disproportionate burden on those investigating, and how such a provision might be drafted so as not to capture deaths which are out with the scope of this amendment. So to conclude, we are not saying no. What I am saying is that I understand the noble lady's concern that the existing statutory provision for preservation of a deceased child's social media data should operate as effectively as possible, and we will consider carefully what further steps could be taken. As I've just mentioned, the noble lady Baroness Kidron and I briefly spoke and agreed to meet, and I'm happy to extend that to an offer to meet both with ministers from Home Office and the Department of Science, Innovation and Technology as well. I look forward to updating the House at report stage on this important topic. I cannot update the House in relation to the issues with the United States now, but I will write to the noble lady in relation to that. And in the meantime, I hope she'll be content to withdraw her amendments.
May I start by accepting all the various offers to meet with the noble lady, and for her tone in her response, and indeed for expanding it to the other departments necessary. But I want to, before I do withdraw the amendment, I do want to make a couple of things very clear. First of all, this sits in the broader issue of failure to make the Online Safety Act implemented properly. It sits in the broader issue of why children are dying at all. And I think I have to say, both on my own behalf, and I will say on the behalf of the bereaved parents, very grateful for everybody's gratitude, but we don't want gratitude, we want action. And I am sorry, but on the actual points, 6 months, the same letter about the guidance that never comes, and I do not accept that there can't be a way of exempting sick children, and I'd like to know how many children died in car crashes because someone was on the phone. I do not think it's an excuse, and I really feel at this point that officials and ministers are way too comfortable with unintended consequences. How about the House starts with actually dealing with the intended consequences of its legislation